June in 2020, and then I joined in December.
I come once in a while to Calcutta.
Oh, really?
Both to the ISI as well as to Bakchi's Institute. I'm calling it the Bakchi's Institute in the sense that...
IDSK, yes.
Rachel, shall we start? Rachel, are you there?
Yes, ma'am. We can start.
So should we start now, or do we need to wait anymore?
No. We can start right away.
Okay. It's a great honor and pleasure for the Kerala Council for Historical Research to have Professor Partha Chatterjee with us today. Professor Partha Chatterjee really doesn't need any introduction at all, but bearing in mind that we have some young students with us as well today, let me at least introduce some major areas of his interest. I'm also very excited that he has agreed to speak to us on such a topical and important area as changing conceptions of citizenship in India. So we are all, of course, without doubt, waiting with great eagerness to listen to what he has to say about that. For most of us who were students in the 1980s, the two texts that made a huge difference to us were Professor Chatterjee's Nationalist Thought and the Colonial World and Nation and Its Fragments. I think this has truly, both these books were so sort of path-breaking and foundational for our thinking. His interests are, the kind of work that he has done, interest is such a sort of vapid word really to use. His sort of really seminal thoughts on major issues range across some of the most important themes of our times today on nationalism, imperialism, popular politics, modernity, and most recently on populism. So without any further ado, I invite Professor Chatterjee to speak to us. Just a brief housekeeping issue, which I must mention now, which is because of bandwidth issues, we normally request all our attendees to actually keep their videos and their microphones off, on mute. All questions at the end of the lecture, the lecture is usually for about an hour, it depends on the speaker. We leave that space to the speaker, and then we have about an hour of questions after that. But we request that all questions be typed into the chat box. One of us will read out the questions so that everybody can hear those. This will actually help with issues of time. Thank you so much. Professor Chatterjee.
Thank you very much, Arunima, and I must thank the Kerala Council of Historical Research for inviting me, and Arunima in particular. It's indeed a great pleasure, and of course, as we were just mentioning a little while ago, the fact that these things can be done online now has actually facilitated many of these meetings, because otherwise I doubt very much that I would have managed to travel all the way to Kerala to do this. There are both good things and bad things about the peculiar situation that we now inhabit. Arunima actually asked me that to speak on citizenship. This is a subject on which I haven't actually written anything, but especially at the time of the protests against the Citizenship Amendment Bill last year, I was asked at several places to speak on this subject. So I did look into this question in some detail, and so I'm happy that I have this opportunity to speak to you in a more kind of informed academic setting. So let me put to you my thoughts on the subject. Let me begin by reminding everybody that it was actually the Constitution of 1950 that gave or that created a concept called Indian citizenship. There were no Indian citizens before that. In the period before independence, there were British subjects, subjects of the Queen, British Indian subjects, and there were subjects of the various rulers of the princely states. And there were some 500 plus princely states in India. Kerala, all of you would know, two major states, Cochin and Travancore. They did not have Indian citizens. They had subjects of the ruling monarch. And so the idea of citizenship, citizenship in the sense of being participants in the sovereignty of the state, which is really what the modern state claims, sovereignty being derived directly from the people, right? Now, that is something which was inaugurated for the first time in India in 1950 with the Constitution. The people gave themselves the Constitution. And so the people of India actually made themselves citizens. So I'm saying this because we'll come back to this at the end of this talk and ask the question, what is it, who, as it were, has authorized all of the changes that have taken place in the conception of Indian citizenship since 1950? It's important to remember that citizenship was not given to Indians by anybody. There was no prior state which gave citizenship to Indians. Citizenship was given to Indians by themselves through the very act of promulgating a constitution. As it says on the very first page, the preamble of the Constitution, we, the people of India, give to ourselves, etc., etc. In 1950, when the Constitution was inaugurated, the Articles 5 to 11, so these were 7 articles which defines or defined at the time Indian citizenship. There have been several amendments over the years which have changed that very understanding of who is an Indian citizen, and that's what I will try to describe to you today. Now, what was this idea of citizenship as it was described in the Constitution? The Constitution declared that any person who lived within the territory of India on the 26th of January, 1950, that's the day when the Constitution was promulgated, and was born here. So anyone who was living within that territory of India in 1950 and was born here, or either of whose parents was born here, or who had lived here for the past 5 years, was a citizen of India. Now, it's important to notice what this definition meant. There was no question about the nationality of one's parents, or one's religion, or caste, or language. None of these things mattered. The only thing that mattered was whether or not one was born within the territory of India, or whether one's parents were born in India, and whether one was living, or ordinarily living within India at the time. That is all that counted. in terms of qualifying to be a citizen. Now, this was more than 2 years after the partition. So more than 2 years had passed. So the initial migration of people between India and Pakistan had taken place. The constitution announced that those who had decided to live in India were now citizens irrespective of their religion. And part of several of these articles, I think Article 6, 7, 8, etc., a procedure was laid down for those who entered India from Pakistan after July 1948 to obtain a citizenship certificate by applying, and then one could get a citizenship certificate for those people who were in those parts of India which had become Pakistan and had decided to come into India and live here. Now, at the time, there were some sections of opinion within India which did not accept this idea of Indian citizenship. All of you are familiar with Savarkar's famous book on Hindutva, but that book was actually written in 1923. So the question of citizenship proper did not actually concern Savarkar at the time. But M.S. Golwalkar, who, as you know, was the chief of the RSS in the 1940s and 50s, Golwalkar wrote a book in 1939. So that was by the time the questions of who would be an Indian and the question of the Muslim claim, although the Pakistan resolution hadn't been passed, but the Muslim demand for a separate identity was already quite strong. So in 1939, Golwalkar wrote a book, which again, many of you would know, We or Our Nationhood Defined. And in that book, Golwalkar claimed that if everyone who lived in India was part of the nation, that would be to uphold what he called a Sarai theory of nationhood. A Sarai theory, meaning it was like a traveler's inn. Anyone could come in and claim to be a citizen. And he said, anyone who, those who were claiming this, Golwalkar said those people were either traitors or fools. This was not a proper idea of nationality. So according to Golwalkar, to properly belong to what he called the Hindu nation, one must be Hindu by ancestry, by race, by religion, by culture, and by language. And by language, he meant they must speak a Sanskrit-derived Indian language. And of course, according to him, every Indian language was derived from Sanskrit. What he excluded was Urdu. Now, those who were not Hindu by this definition would have to either fully assimilate into Hindu culture or live at the sufferance of Hindus. Right? They must leave India as soon as the Hindus want them to. After partition, leaders of the RSS and the Hindu Mahasabha said that there should be a full transfer of minority populations between India and Pakistan. All Muslims must go to Pakistan, and all Hindus must come to India. Now, in actual fact, as we know, there did occur something almost like a transfer of populations in Punjab. And that occurred largely through the horrific violence and killings that took place in Punjab at the time of partition. So soon afterwards, they're largely, most Hindus and Sikhs living in the western part of Punjab migrated to India, and most Muslims living in the eastern part of Punjab migrated to Pakistan. So on the Punjab border, there were really very few minorities who were left on each side. But the situation was quite different in Bengal, because in Bengal, no such massive transfers of population actually took place at the time of partition. The migrations took place very slowly over time in spells, and the best estimates that I know, between 1947 to 64, something like 8 million Hindus came to West Bengal, more than 1 million came to Assam, and 1 million or so to Tripura. While more than 1 million Muslims went to East Pakistan from West Bengal. After 1971, around 2 million Hindus came into West Bengal. 71, the time of the liberation war in Bangladesh. Today, there are some 25 million Muslims in West Bengal and 12 million Hindus in Bangladesh. So in both these countries, there are significant minority religious populations. Now, as I told you, that the Constitution defined citizenship as it stood in 1950. Subsequently, the question arose, how would citizenship be defined in future for those who were born in India or who came from elsewhere? And this was answered by the Citizenship Act of 1955. In that act, there were 5 ways in which one could become a citizen of India. And let me go through these 5 specific ways, because not all of them, but several of them would be changed later on, subsequently. The first category was all of those born in India before or after 1950, and this was 1955, therefore, all of those born in India before or after 1950 was an Indian citizen by birth. There was no question, not even a question of the citizenship of one's parents, right? It didn't matter. Even if one's parents were foreign, but one was born in India, one could become an Indian citizen. Govind Ballabh Pant, who was then the Home Minister, who introduced this bill in Parliament in 1955, he said at the time that the law was being enacted following the most progressive ideas on citizenship in the world. And that was what in the West, in most European countries, was known following the Roman law concept, jus soli, which basically means the law of being born on the soil or the territory. So if one is born within the territory of a country, one was a citizen. And this was the law that applied in the United States. It still applies in the United States. Anyone born within the US could become a citizen, irrespective of who their parents were. This is the same law which applies in most South American countries. This was the law, in fact, in the United Kingdom also, until 1983, when the Nationality Act was passed by the government of Margaret Thatcher. That is when the definition was changed, and at least one parent had to be a British citizen, a UK citizen, for someone to become a British citizen by birth. But otherwise, this was indeed regarded as the most sort of liberal, progressive idea, and that is what was followed in India. Remarkably, it would be interesting to note that that this was in fact the rule in Pakistan. This was the Pakistan Citizenship Act of 1951. As far as I know, the same act is still valid. anyone born in Pakistan, irrespective of the parent's nationality or language or religion, could become a Pakistani citizen. And this was not uncommon. So as I said, the 55 Act, this rule of citizenship by birth within the territory of India was in fact a fairly well recognized and understood to be the most progressive conception of citizenship at the time. Now, there was a different notion of citizenship in most European countries. In the European countries, they defined citizenship by blood descent. That is to say, what was called jus sanguinis, descent by blood. And here the nationality of one's parents or ancestors determined citizenship. And this was essentially an ethnic conception of citizenship. That is something which still holds in most European countries. As many of you would know, that there have been many controversies about what happens to the children of many immigrant families. Of course, as you know, from the 1950s onwards, most European countries, there were many immigrants from their former colonies. So it could be North Africa, the Caribbeans, South Asia, Turkey, all of these places. And the question arose, what would happen to the children of those immigrants who were born in the European countries? And gradually, under all kinds of clauses and so on, they have been granted citizenship in recent times, but that continues to be a matter of much controversy. As you know, immigration is a huge matter of controversy in Europe today. Now, so that's citizenship by birth. The first method of becoming an Indian citizen. The second method of acquiring Indian citizenship by this 1955 Act was by descent. So if someone born outside India, but whose father, and this was the original law, whose father was an Indian citizen, could become an Indian citizen. Someone born outside India, but born of a father who was Indian, could become an Indian citizen. In 1992, this obviously male-centered definition was changed, and the rule now is that if either of one's parents is an Indian citizen, then even if one is born outside India, one could still become a citizen by descent. The third method is by registration. Now, several categories of persons not born in India could become citizens by registration. So, for example, a person, one of whose parents or grandparents was Indian, or someone who was married to an Indian and who was living in India for at least a year, could, through registration, become an Indian citizen. This involves a process of application and approval by the authorities. And of course, many people have become citizens by registration through this particular method. The fourth method is naturalization. So if a foreign person lives in India for at least 8 years and wishes to live permanently in India, such a person may be given citizenship by naturalization. If such a person, so one has to apply and so on, but one has to be living in India for at least 8 years in order to qualify. If such a person has made a distinguished contribution to science, philosophy, art, literature, or world peace, then he or she could be naturalized as a citizen at any time by the government. And for instance, distinguished persons such as, I mean, these are the names that I immediately could think of. There must be many others. The singer Bade Ghulam Ali Khan, who came from Pakistan, was naturalized as an Indian citizen. The scientist J.B.S. Holden, who was British, became an Indian citizen this way. Mother Teresa became an Indian citizen this way, and others were given citizenship this way. According to an answer given in the Rajya Sabha last year, between 1915 and 1920, nearly 6,000 persons were naturalized and given citizenship in 5 years, 6,000. Among them, 700 from Pakistan. So this information is significant in the context of the CAA debates, which I'll come to in a short time. It shows that persons from neighboring countries could be given citizenship even under the old act. So the question could be raised: why was it required to have an amendment to that act? We'll come to that question in a few minutes. And then finally, there was a fifth method. The fifth method comes into effect when a new territory is incorporated into India. So when a new territory is added to India, the people living there could become citizens. This happened in 1954, when the French territories of Pondicherry and Chandernagore were included in India. It happened again in 1961, when the Portuguese territories of Goa, Daman, and Diu were included. In 1975, Sikkim was annexed and included within India. So the people of Sikkim became Indian citizens. Most recently, in 2015, some 15,000 persons from Bangladesh became Indian citizens, and some 35,000 Indians became Bangladeshi citizens when several hundred enclaves were exchanged between India and Bangladesh. This is through an agreement between the two countries in 2015. So this was the fifth method, incorporation of territory, by which people could become Indian citizens. So those are the five methods defined in the Citizenship Act of 1955. As I'll now proceed to explain to you, many of these conditions were changed since 1955. The next chapter in the story of citizenship moves to Assam. So there's been a long-standing complaint of Assamese cultural leaders and political leaders against the settlement of Bengali peasants from Eastern Bengal since the early 20th century. This is a long-standing process. There are all kinds of historical accounts as to why British colonial officials, in fact, encouraged this settlement because the Brahmaputra Valley in particular was considered to be relatively underpopulated. There were lots of land which was not cultivated at the time. And the districts of Eastern Bengal there was a huge population pressure in those areas. So the colonial officials, in fact, encouraged migration of farmers, Bengali farmers, from the East Bengal districts, particularly Mymensingh and Rangpur and districts like that, to move into Assam, to clear forests, to occupy what was known as the Chor lands, that is to say, these islands that form in the middle of especially the Brahmaputra River. These are all very fertile lands, but these were people who settled there, brought the land under cultivation. They founded new villages. But the problem was that the migration continued after 1947, even after the border between Bengal and Assam became an international border. As these peasants, they brought new land under cultivation and founded villages. The migration into Assam was much higher than anywhere else in India. Assamese leaders were concerned that the Assamese people might soon be outnumbered by Bengalis. And so there was earlier a movement through the 1960s in particular, which became somewhat violent, which was a movement to evict Bengalis from Assam. The Congress leadership at the time, the Congress was obviously in power at the time, they didn't encourage this movement to grow very much because Congress being an all India party, they were not keen to push what was clearly an ethnic conflict. And in further, since most of these Bengali farmers who had moved in were in fact Muslim, there was also a communal dimension to this. And so the Congress party and the government didn't particularly encourage this anti-Bengali movement at the time in the 1960s. Now, the movement changed character in the 1970s, late 1970s, a movement against what it was now called the foreigners, the anti-foreigner movement. It was no longer specifically anti-Bengali. Anti-foreigner movement began in 1979. It was led by the All Assam Students' Union, ASU. In 1983, the ASU and then what became the Assam Ganaparishad, the Agapo AGP, boycotted the assembly elections of 1983, and the elections were actually quite violent. The central government then enacted what was called the Illegal Migrants Determination by Tribunal Act, IMDT, which declared that all matters of citizenship would be decided by the central government. That was the first provision of the act. And then an exercise would be carried out of identifying all Indian citizens in Assam. It set up tribunals to look into allegations against persons suspected of being illegal migrants. The accused had the right to present evidence to the tribunal to prove that he or she was not an illegal migrant. So in fact, it gave the accused person, the person suspected of being illegal, a chance to prove that he or she was not, in fact, an illegal migrant. But more importantly, it also set aside the provision of the Colonial Era Foreigners Act. There was something called the Foreigners Act, which was enacted in 1946, which the Foreigners Act actually put the onus of proof on the accused person. So it was the accused person who had to prove that that person was not a foreigner. That was set aside by the IMDT Act, and it was laid down that the onus of proof would be on the officer or the agency bringing the charge against a suspected illegal migrant. Now, so this was the procedure that the IMDT Act laid down, 1983 Act. But it made it quite difficult to legally identify so-called foreigners. And ASU and AGP began to condemn the IMDT procedure quite soon. The next major step in changing the concept of citizenship was taken in 2003, when the Vajpayee government amended the Citizenship Act. I've excluded one important, there should be something else, which is, of course, the Assam Accord, which was put in place soon afterwards, after the IMDT Act was passed. The Assam Accord, which happened late 1985, early 1986, between the new Rajiv Gandhi government and the leaders of the Assam movement. The accord basically said, put the date or cutoff date at 1971, and said that anyone who had entered Assam after 1971 would have to prove that that person had valid entry permits. Otherwise, that person was illegal. So that was the substance of the Assam Accord, and this then guided the procedures of the IMDT Act, of the tribunals. So that would be what was to be tested. Following the Assam Accord, the next major step in changing the concept of citizenship was taken in 2003, when the Vajpayee government amended the Citizenship Act to introduce the new category of overseas citizens of India. Now, citizens of other countries who were born in India or whose parent, grandparent, or great-grandparent was an Indian citizen could be given overseas citizenship of India. So this OCI, which even though it would not allow that person to vote or hold office in India, he or she could enter the country at will and hold property and engage in business like any other Indian. So except for the political aspect of citizenship, the one of being a voter and a party to the constitution of the government, in most other matters, the OCI was given pretty much the same kinds of facilities as any other citizen of India. The same amendment of 2003 introduced into the law the concept of the illegal migrant. Now, this is significant. It was not much remarked upon at the time. The OCI was much celebrated as a completely new conception of including within the broader category of Indians, many of those who were of Indian descent but lived abroad. But the same amendment of 2003 introduced into law the concept of the illegal migrant. Who was an illegal migrant, according to the law? It said that anyone who was in India without a valid entry permit was an illegal migrant, and such a person could not be given citizenship by registration or naturalization. So if a person was an illegal migrant, all path to citizenship was closed by this amendment. Now, while much was made of the overseas citizen, this amendment was not much noticed at the time. Its significance has become much clearer in recent years. The 2003 amendment also tightened the condition for citizenship by birth. So you remember the original argument was that anyone born in India before 1950, or someone born outside India but whose parents were born in India could become an Indian citizen. Now, this was changed in 2003. The changes were as follows. So those born in India between 1950 and 1987 could become citizens. Born in India between 50 and 87. Why 87? This was to accommodate the Assam Accord, which was 1986. So everyone who had come into India before 1986, or 87 actually, before the Assam Accord, would be citizens according to the old Citizenship Act. For those born between 87 and 2003, at least one parent would have to be an Indian. At least one parent would have to be an Indian. So it was no longer possible for someone born of foreign parents, but born in India, to claim Indian citizenship. For those born after 2003, both parents have to be Indian. Now this shows, first, that there has been a clear shift from the jus soli, that is to say, citizenship by birth within the territory, that concept, to the jus sanguinis, or citizenship by blood descent. There's been a clear shift in that conception. And second, that while new citizenship criteria made the status of many who lived in the country uncertain, many foreign citizens of Indian origin could enjoy privileges similar to those of citizens. So this was another rather peculiar effect of these amendments, that many citizens, that many people who had been living in India for decades, probably generations, but their status became uncertain because of this criteria. Did they or their parents enter the country with valid documents? That made their status uncertain. And yet, many foreign citizens who didn't even live in India could actually enjoy privileges pretty much similar to most Indian citizens. Now, the roots of the Citizenship Amendment Act of 2019 lie in the difficulties in implementing the Assam Accord. Assam Accord of '86, as I said, the IMDT tribunal system had been set up, but it didn't move very quickly. So the ineffectiveness of the IMDT Act became a major concern of the leaders of the agitation in Assam to remove foreigners. In 2000, this is an interesting move that the main attempt to implement this accord shifts from the government side, the executive side, to the judiciary. In 2000, Sarbanand Sonowal, who was the former ASU leader, and at the time, in 2000, he was an AGP member of parliament. He is now, of course, the BJP chief minister of Assam. Well, he filed a petition in the Supreme Court demanding the repeal of the IMDT law. In 2005, the Supreme Court declared that the IMDT Act was unconstitutional. It directed that all cases under the Act, which were at the time in all kinds of, on the various tribunals, would be brought under the jurisdiction of 21 new tribunals, where they would be decided under the Foreigners Act 46. Now, remember, the Foreigners Act puts the onus of proof on the person who had been accused of being a foreigner. So this meant that it would be up to the accused to prove that he or she was not an illegal migrant. The Supreme Court took over the responsibility of supervising the work of the tribunals and updating the National Register of Citizens, or NRC, in Assam. So this takes the whole dispute onto a different track altogether. Millions of cases of those whose citizenship was officially marked doubtful came to the tribunals, these new tribunals. From 2013, the two judges of the Supreme Court, Ranjan Gogoi and Rohinton Nariman, kept pressing for the completion of the process. In 2019, the Assam NRC was published. It showed that 19 lakh people were illegal. Of them, 7 lakh were Bengali Muslims and 12 lakh were Bengali and Nepali-speaking Hindus. This put the ruling BJP in an awkward position. They had always claimed that Hindus arriving from Bangladesh were victims of religious persecution and must be given refuge, while Muslim migrants were illegal infiltrators. That so many Hindus had been found to be illegal was an embarrassment. On the other hand, Assamese leaders claimed that the NRC had undercounted foreigners, and there were actually many, many more. So this was the immediate background to the Citizenship Amendment Act of December 2019. It laid down that Hindus, Sikhs, Buddhists, Christians, Parsis, and Jains, 6 religions were mentioned. So people following these religions who had come from Afghanistan, Pakistan, and Bangladesh, 3 neighboring countries were mentioned by name. Those who had come from these 3 countries before 2014 so the date was 5 years previously, were victims of religious persecution and would not be declared illegal migrants even if they did not have valid entry documents. Now, clearly, this was an attempt to get around the 2003 amendment provision that anyone who did not have valid documents would be declared illegal migrant and therefore could not be made a citizen. In order to get around that 2003 provision, this was the new amendment that was introduced, that for these categories of migrants from these 3 countries, even if they did not have valid documents, they would not be declared illegal migrants. And therefore, they could be given citizenship, and an expedited process of registration was meant to be introduced. The one religion that was excluded was Muslim. This was the first time that a religious category was introduced into the legal definition of citizenship in India. There were widespread protests around the country against the CAA. All of you know this. The CAA was basically described as having betrayed the pluralist conception of citizenship which had been laid down in the Constitution. You'll remember that one of the favorite things that were done in most of these protests was to read out from the preamble of the Constitution. In Assam and the other northeastern states, on the other hand, there too, the CAA was condemned, but for a completely different reason. There were protests demanding that all foreigners be removed from the region, irrespective of religion. All of these protests were overtaken, of course, by the outbreak of the COVID epidemic in March 2020. Now, before I close this discussion, let me end by referring to Ambedkar, who thought very carefully about the problem of Indian citizenship. He believed that all those who agreed to live under the same constitution must be considered citizens. If there was a significant group that did not agree to do so, that is to say, did not agree to live under the same constitution, then, and if it was feasible for them to form a separate territorial nation state, then they should have the right of self-determination and live separately under a different constitution of their own choosing. That is why Ambedkar supported the Muslim League demand for Pakistan. And of course, many of you know, he wrote a whole book on this subject soon after the Pakistan resolution was adopted. But every territorial nation state will necessarily have minorities. And Ambedkar gave examples from all over the world, especially the examples from Europe after the League of Nations made the minority question such a major issue at the time. Every territorial nation state will necessarily have minorities. Otherwise, so Ambedkar's claim was that these minorities must be given necessary protection to maintain their distinct identities. Otherwise, there would be a permanent communal majority that would threaten minorities. Hence, he argued for special constitutional provisions for scheduled castes and tribes and for religious minorities. Incidentally, he also argued for a federation of small monolingual states. Now, what we see today is an attempt to create a permanent communal majority in India and change the original idea of citizenship by birth within the territory to citizenship by descent and religious identity. This is a fundamental reformulation of the idea of the Indian Republic as it was imagined in 1950. So my final question to you is this the constitution that the people gave to themselves in 1950? And if not, who is authorizing these very fundamental changes in the conception of citizenship itself? What is the sanction, the power behind this? So let me stop here, and I'll be most happy to hear your comments and questions. Thank you.
Thank you so much, Partha. The talk is now open for discussions, and once again, just to repeat what I had said at the beginning and what I typed into the chat box, all questions should be typed into the chat box. We shall read those out. May I request my colleague, Dr. Rachel Varghese, to take it on from here? Thank you.
Thank you, Professor Aruna. Thank you, Professor Chatterjee. We'll wait for a couple of minutes for the questions to come in.
There's usually a little bit of a warming up period. I think that's one of the disadvantages of the online mode. Offline, I think people are far more forthcoming with their questions.
Yes, there's also a difference between speaking a question and writing a question.
I know, but the problem that we found when people speak the questions is that it takes up more time. Yeah. It actually allows more people to participate when it's written.
We have a question in the chat box. Shall I read it out?
Please read it out.
It's from Meenakshi Shivram. If people of the 1950s gave themselves the constitution, do people of 2020 have to be bound by it?
No, obviously not. Now, the interesting question is, there are changes in the law, which is, of course, something that Parliament can do. And the Parliament, as we know, is elected according to constitutional principles. So the interesting question is whether the cumulative effect of changes in the law can actually end up changing the constitution itself. You see, now this is the distinction. It seems to be a fine distinction, but all the changes in the conception of citizenship that I've described, none of them was done through a constitutional amendment. The constitution was not changed. The constitution still remains exactly what it was. What has changed is the application of that constitutional idea, which initially was done in the Citizenship Act of 1955. And then it's through changes in that 1955 Act, a whole series of changes, that the effect has been to, in fact, change the very idea of citizenship itself. And this is the interesting question. If it was simply a question of changing the constitution, then there would have been a procedure which the constitution itself lays down. So that's the interesting question, is what is the politics behind changing the law in order to, in fact, change the constitutional, a very fundamental constitutional idea. As I said, that there must be a change in the politics, right, which says that we cannot accept the old idea, the 1950s idea, that anyone who is born within India and lives within India must be considered an Indian citizen. That is clearly significant sections of opinion don't think that's a good idea. And so that is the interesting question that has to be pondered. Do people now believe that no, descent by blood descent, ethnic characteristics are more acceptable rather than simply the fact that people agree to live together? So that's the question I think that needs to be thought about.
The next query is from Prachi Shukla. Sir, how has been the impact of CAA on border states other than Assam?
Well, one important state is where I live, which is West Bengal, where this CAA has had quite a significant impact. It's, you know, and there are different groups who've had different kinds of responses to this. One important group has been a scheduled caste called Namashudra, most of whom now live in West Bengal are migrants from East Pakistan and later Bangladesh. These were people, many of whom actually came into West Bengal through the 1950s, 60s, and then a large chunk in 71 or just immediately following 1971. Now, most of these people have been living in West Bengal or in India ever since then. There are now at least 3 generations who have been living in India. Many of them have, or most of them, have all of the papers that any other Indian of that age would have. As you know, I mean, until very recently, most people did not have birth certificates. I, for instance, never had a birth certificate. And so the only papers one had were, earlier, the only actually official paper one had was a ration card. There were no other papers. And then people acquired things like voter cards. Those who paid income tax had PAN cards. Now, of course, almost everybody has an Aadhaar card. Some people I know from this community who have traveled abroad even have passports. And yet, and this is the interesting question, they keep saying, but we still don't have any proof of our citizenship. Nobody has actually, no government has given us a certificate of citizenship. And the anxiety became even stronger after what happened in Assam. Because in the Assam case, it was found in these tribunals that many people who had all of these documents were still said to be illegal migrant because the suspicion was that these documents could have been procured by making false statements. And so the requirement was to prove, for instance, that the parents had entered the country legally. And of course, this was, in most cases, completely impossible to prove. In the Assam case, there were even many cases of people actually having a passport. And the passport, as you know, declares on the first page that so-and-so is a citizen of India. That is an official stamp. And yet that passport too was rejected as proof on the ground that the passport could have been obtained by making false declarations. So this creates this whole atmosphere of anxiety about how one would be accepted as citizen. And this is where the CAA is very often, this is happening right now in the election campaigns that are going on today. The BJP is actually saying, look, we have passed the CAA, and the CAA actually lays down the procedure which says, if you have come from Bangladesh and you're a Hindu, then irrespective of whether you have papers or not, you can be made a citizen. That's what we have been able to do. Now, this is the kind of impact the CAA has had on states, not just Assam and the northeastern states, but elsewhere. I'm sure there will be effects of this, and depending on the official position. Don't forget that initially, after the CAA was passed, the Union Home Minister announced in Parliament the famous statement about the chronology, which was said, now that we've passed the CAA, we will now do the National Register of Citizens for the whole country. So that is to say, everywhere in India, people would have to prove that anyone whose status was said to be doubtful would have to prove that that person was genuinely a citizen. So that's the kind of implication that the CAA had at the time, and these were expressed at the time of the various anti-CAA protest meetings. As you know, the protest meetings were quite unusual because they were not the usual political meetings. Most of those meetings, as many of you probably even participated, there were people who had never attended political meetings before who joined these meetings. And so clearly there was something that created a great deal of suspicion and anxiety among people about what the impact of this new act would be on ordinary people.
Thank you. The next query is from Rennie Thomas. Thank you very much for a great lecture. I am just curious if one can use the same debates on citizenship to understand Sri Lankan question in the southern part of India. It would be interesting to know if there were debates on cultural transactions between Ceylon and southern part of India, especially Kerala and Tamil Nadu. And if that then framed the debates on citizenship differently. Thank you very much.
Now, that's a particularly interesting question. At the moment, I can't recall all the specific details of the various agreements. There are actually official agreements between the Indian and Sri Lankan governments over, and there were different kinds, different groups of migrants from Sri Lanka. Even there was the famous case of what were called the tea garden Tamils. These were people who had been taken to Sri Lanka, many in the 19th century or early 20th century, to work in the tea gardens, mostly in the Kandy area of Sri Lanka. And they were never considered Sri Lankans proper. They were part of a kind of migrant labor status. And there was an agreement by which many of these tea garden laborers were returned, or their children and grandchildren, in many cases, were returned to Tamil Nadu. They were settled in specific camps and rehabilitation centers in different places. Some of them, I believe, have later acquired Indian citizenship, but not all. And there were special provisions that were made for them. So that's one kind. And the other were, of course, those who came more recently because of the conflicts between Sinhalese and Tamils and the military actions in Sri Lanka. And so many of them were refugees in that sense. I believe there are still many who are in Tamil Nadu, and their status remains unclear. I don't think they have been. For instance, it's interesting that Sri Lanka and these people have not been included in the CAA. They are clearly not part of this discussion. It's been often remarked as to why the three countries chosen were only the Muslim countries. So, for instance, Sri Lanka is not mentioned, Myanmar is not mentioned. And so that's an interesting kind of debate, which again goes to show that there is a very specific kind of ethnic citizenship idea that informs the present attempt to change the definition of citizenship. That the idea that Hindus who have been persecuted for religious reasons are the ones who should be given refuge in India, but not necessarily others. This is the interesting kind of distinction that seems to be made. It's not made officially, but all the specific acts seem to suggest this, because there's no question that migrants from Sri Lanka, who are also Hindu mostly, have not been categorized within the same kind of legal framework. They occupy a different status.
Thank you. The next query is from Meenakshi Senan. Are there any geopolitical reasons behind the choosing of certain categories to be citizens under the CAA?
Well, as I said, there are three neighboring countries that I mentioned, all three being Muslim countries. Now, why not the others? Yes, there are geopolitical reasons. There is a clear attempt here to try and distinguish between countries where it is said that Hindus are victims of religious persecution, because the suggestion almost is that Muslim countries by nature will persecute religious minorities. The question of Sri Lanka, therefore, is left out. The question of Myanmar is left out, although in Myanmar there is no question that, for instance, the persecution of the Rohingya Muslims would qualify if there is any definition of religious persecution carried out by state authorities. Well, that was one. It was a classic example, but that is clearly excluded from this definition. So the geopolitical factor is one where India clearly is trying to project a very particular kind of identity in the neighborhood, and defining itself in certain kinds of ways in relation to some neighbors and differently in relation to others. That seems to be the logic behind this particular kind of distinction that's being drawn.
Thank you. The next is a two-part query. It's from Professor G. Arunima. Thanks so much for unpacking this history with such clarity. It would be great to hear you reflect on two different kinds of issues. One, what has the Indian state's relationship to illegal immigration outside of formal citizenship laws? After all, there has been a long history of quote-unquote illegal economic immigration to India, especially Nepalis, but also Bangladeshis, but also Afghans and others. Despite this, one hasn't heard of too many formal responses to such quote-unquote illegality. The second part of the question is, aren't the NRC and NPR more dangerous than the CAA by itself?
On the first question, the question of illegal economic migration is actually included within the idea of infiltration from Bangladesh, because no distinction is made. You know, this whole question, this is a very interesting question, actually. This whole question of what allows for migration from, let us say, Bangladesh into India to take place. Why is it that migrants feel it possible to come and settle down in particular places? What do they think would be their sources of livelihood? Would they be welcome or not? And clearly, migration takes place in significantly large numbers only if there is some kind of hospitable place for them to go. So for a long, long time, for instance, the migration into the Assam Brahmaputra Valley areas was possible because, honestly, these people were not taking away other people's lands. They were actually clearing land and bringing land under cultivation. And that was the original idea. If in fact they were actually coming into conflict with local people over land, it would have taken a very, very different kind of dimension, right? That is not what is happening. I often think of why, for instance, people don't make the comparison between Indians, for instance, who seek to travel abroad in order to find a livelihood, right? Of different kinds, both white collar as well as people who are otherwise, for instance, manual workers or workers of different kinds who want to go to Europe or to Britain or to the United States, migrate in order to find work. The Indians are no different in this respect from people from Bangladesh or from many, many other parts of the world. And yet the distinction is clearly drawn. And it's interesting that you make the argument, comparison with Nepal. Of course, the border between India and Nepal is open. So, people can travel across that border and people are free to live and work in either country. But the distinction is not, the distinction is in fact clearly made between Nepalese who come to India to work and Bangladeshis. The Bangladeshis somehow are in a different category. And of course, the reason is entirely because the argument would immediately be made that there is actually some deep-seated conspiracy to infiltrate these border regions of India with more and more Muslims in order to change the demographic balance and, in fact, prepare the ground for another partition. That is the constant rhetoric in which this idea of... So the economic migration question is not treated as an economic migration at all in this particular case. On the question of NRC and NPR, yes, because even without the Citizenship Amendment Act, the NRC procedure was already a horrific procedure. This was shown in Assam, right? The Assam experience actually showed, the bizarre extent to which this procedure of trying to identify people of doubtful, citizenship status, how bizarre this procedure could be. And the CAA, as I said, was brought in to meet a particular awkward consequence of that NRC procedure in Assam. It was to try and get around that embarrassing situation that the amendment was brought in to, as it were, allow for granting citizenship to illegal migrants who were Hindu and exclude those who were Muslim. That was the basic point of the Citizenship Act. But the NRC procedure itself, wherever it may be carried out, contains this basic legal anomaly that officials or anybody on the basis of, nobody knows what the basis of the allegation would be, could actually ask anyone to prove that one is living in India on the basis of a legitimate entry permit, right? Or on the basis of legitimate documents. Anyone could be asked to prove this, and the onus of proof would be on the person who is being accused. So that's the basic legal framework of the NRC. And if that is extended to other parts of India, one can just imagine what kind of arbitrariness and misuse that kind of legal procedure can be put to. So that is, you're right. I mean, that itself is the real mischief. What's happened with the CAA is actually, given the consequences of that, procedure, in a, you might say, what was only a subtext has now been acknowledged in the law as part of the definition of citizenship. That is to say, citizenship by religion. That has been explicitly brought into the law. That didn't exist earlier.
Thank you, Professor. The next query is from Ramkumar Thakur. Do you think ahistorical usage of category of migrants/migration and original/aboriginal inhabitants in both academics and popular discourse aggravates the precarity of citizenship claims?
This is a very large question to answer, because the issue of migration, as it's been used in the context of the Citizenship Act, is specifically in relation to the territorial boundaries of a state, legally defined territorial boundaries of a state, and the legal procedures of moving in and out of that territory. That's a very specific understanding of the idea of migration. Now, if one is to extend this to earlier histories, when this idea of a nation state did not exist, the idea of territorial sovereignty did not exist, then of course, the question of migration becomes far more complicated. Question of who is an original settler and who is a migrant becomes often completely undecidable. And if you honestly go back far, far enough, virtually everybody is a migrant from somewhere or the other. If you have to believe the genetic scientists, the entire human species actually began from a few places in the north of Africa, and then migrated all over the world. So in some ways, everybody is at some sense or the other child of a migrant. But there are very specific contexts in which it is meaningful to speak of original settlers or aboriginals and later migrants. And those have very specific contexts. The context in which this particular discussion is carried out is in the more restricted sense of migration across international borders as defined by the contemporary nation states.
Thank you, Professor. Our next query is from K.C. Shankar Verma. Thank you very much for the illuminating lecture, Professor. My question is, do you feel print capitalism has triggered the idea of a nation state and subsequently the idea of a citizen? Does print capitalism in this regard still exist, or has audio-visual means of reproductions already swallowed us in order to prove to the world outside that, quote unquote, yes, we are the citizens of a nation? Something in Benjamin's language, a homogeneous empty time. Thanks.
Well, since you clearly know Ben Anderson's book, I don't have to repeat why he found print capitalism so important. He was specifically speaking, of course, of the rise of nationalism first in the Americas and then later in Europe from the late 18th, early 19th century onwards. And there clearly, as he was trying to show, it was the combination of capitalism with the technology of print and the kinds of printed material that came to be circulated through print, especially through the whole range of government and bureaucratic literature, actual creative literature, and he was particularly interested in the novel and the serialized novel in particular. And what one can go on to mention the spread of education, the importance of textbooks, school texts, and so on, to create this sense of belonging to a single community, sharing a common language, which of course is a very strong feeling that is part of the sense of belonging to a nation. You were completely right in suggesting that the technology of print has been superseded in the 20th century by audiovisual technology. We can think of the radio, the cinema, of television, and of course, more recently by a whole range of digital technologies that have now far overtaken the old print technologies. In the Indian case, what's interesting is that there is an argument to be made that print technology actually never reached beyond a very small section of the people, because after all, how many people actually read? How many people read newspapers, for instance? Even in the period of the national movement, the freedom struggle, yes, the print medium did play a very important role, especially among the leading politically articulate sections of the people. So the middle classes, for instance. But beyond the middle classes, there were very few people who actually read. So how was the idea of nationalism conveyed to them? And there, even then, there was the role, of course, of performance of different kinds. But these were face-to-face contexts of performance. So you can think of theater, you can think of various performative arts, even in rural areas, songs which circulated by mouth. And then you had the gramophone records. Radio never was a very widely circulating technology until much later, the 1960s, until the rise of the transistor radio, the battery-operated transistor radio. That's 1960s onwards. Then, of course, the radio becomes widely popular too. And then, of course, you have all the while you had cinema. So from the 30s onwards, cinema was a very important medium through which this idea of imagining a nation, imagining all of these people who are otherwise completely unknown to each other, but somehow belonging to a nation. Cinema, radio. Think of the way in which sporting events would unify the sense of belonging of an entire people. A national sports team performing in the international arena and the whole country, in a sense, sharing that same experience. That's the kind of thing that, as Anderson says, print technology was doing in the 19th century through the newspaper. But in the 20th century, you have all of these other technologies who are probably doing it at a much greater speed, as well as traveling much, or including much greater numbers of people.
Thank you. The next query is from Professor Tapati Guhathavetta. What was the legal justification for the exclusion of neighboring countries, Burma, Nepal, China, and Sri Lanka, in the CAA? This question has become of very pressing importance in the context not just of the Rohingya exodus, and now with those fleeing the massacre in Myanmar.
Yes, the question was raised at the time. The arguments given were very political arguments. The argument was that if there was religious persecution in other countries, why should India take the responsibility of giving refuge to anyone other than Hindus? The argument was that India is the only country that Hindus can call their home country, whereas Muslims could go to so many other countries in the world. So basically the argument was that let other Muslim countries take care of the Rohingya Muslims. India can only deal with Hindu refugees. And this was a blatantly communal but political argument. And that's the argument that was effectively given for excluding Sri Lanka, Myanmar, Nepal, etc., from the list of neighboring countries.
Thank you. I'm sorry, I missed an earlier question from Manashri Mishra. In Assam, there has been a demand to change the cutoff year of citizenship to 1951 instead of 1971, as prescribed in the Section CA of the Citizenship Act. How would you look at this demand? Is it justifiable given the long struggle against illegal immigration in the state?
See, this again raises this question of what is the source of the anxiety? And the source of the anxiety clearly is, and many of the leaders of the movement in Assam have expressed this, that it doesn't necessarily matter if, for instance, these migrants end up speaking Assamese, because many actually do. It's only to be expected, because clearly the children of these Bengali speaking migrants, when they go to local schools, as they all do, they learn the local language. It is only to be expected that the younger generation among these migrants don't necessarily want to live the same lives in these remote villages. They want a better life, possibly in the cities. And for that, they acquire the Assamese language, they speak the Assamese language. But the suspicion is that, therefore, many people who pretend to be Assamese are actually not. They are not ethnic Assamese. So one of the things that was not so strong earlier in the anti-foreigner movement, but increasingly is now becoming prominent, is the emphasis on the ethnic Assamese. So the argument almost is that it doesn't matter if non-ethnic Assamese learn to speak Assamese and become, as it were, assimilated or part of a public culture of Assamese speakers. That will not do. You will have to prove yourself to be an ethnic Assamese. And this is why this cutoff date is being pushed back, almost to say that even if, just 1971 is much too recent, you have to show that your parents or grandparents were living in Assam in the 1950s. And only then will you be accepted as a genuine citizen. So that seems to be the logic that is driving this argument.
Thank you. We have one more query in the chat box. This is Meenakshi Shivram. Your logic may not be able to solve problems of human existence, said Proust. In a world of nations and boundaries, in your opinion, should India have some way of identifying citizens?
Sorry, of identifying?
Of identifying citizens.
Some other way.
Yes,
I wasn't able to understand the question. No, you see. No, why don't you repeat the question?
Yes, sure. Your logic may not be able to solve problems of human existence, said Proust. In a world of nations and boundaries, in your opinion, should India have some way of identifying citizens?
Yeah, so if you are asking if it's possible to identify citizens without regard for nations and boundaries, it becomes difficult to to think of procedure. One interesting example is Europe, for instance. Now, Europe for a long time had very strong boundaries between all the European nations. And as I said, that in Europe, the idea of ethnic nationalism was deep-rooted. It was understood that you had to be ethnically German in order to be German, or ethnically Polish in order to be Polish, so on. But through the experiment of the European Union and the fact that, yes, you could be a German citizen or an Italian citizen, but you had the right to travel, to study, to work, to hold property in any country of Europe. Now, that clearly was a very significant change in the conception of citizenship, which actually minimized the importance of territorial boundaries, at least between the European nations. Now, in the Indian case, very interestingly, if you think, India is not necessarily completely exclusive in this case. For instance, India has open borders with Nepal. India has open borders with Bhutan, right? It's there. It's possible. But of course, it's completely unimaginable at this moment to think of open borders with Pakistan or open borders with Bangladesh. That is the interesting question. Is it possible to build sort of larger sense of communities of nations? Nation states don't necessarily dissolve themselves, but is it possible to think of even nation-to-nation agreements which allow for greater freedom of movement across borders? Now, that requires a particular kind of political will. At the moment, as I've been trying to explain to you, the political will is actually in the opposite direction. The political will, as expressed by recent governments in India, is in the opposite direction. It's to actually close. Even now, I mean, if you think of the recent disputes that have broken out with Nepal over the border, it is possible that even that open border may be closed in some near future. So that is it seems to me that the tide is actually, at least at this time, it's moving in the other direction. It's moving towards closing borders rather than opening them.
Thank you very much, Professor. We have come to the end of the questions in the chat box. Over to you, Professor Arun.
If there's any one last pressing question, we have time for that. And if that last pressing question needs to be spoken, we allow you that as well. So if there's somebody who needs to ask a question, please do. Michael, do you have a question? Michael, is there a question or a comment?
Yeah, Professor Partha Chatterjee, I was wondering whether it would be a useful exercise to link the concept of citizenship with a location-based understanding in terms of identification, not only in a restricted contemporary period, but also historically. For instance, you yourself in your earlier writings, like you mentioned about nationalist-like movements, even before the national movement took shape in India. Now, reading on that kind of a point, I've come across 18th century travelogue in Malayalam of two people who went all the way to Rome and Lisbon. And they were very closely identified with the American War of Independence, because at that time Washington was a hero of the European elite, and these people, one of them even took a PhD from Italian university. So with a sense that was much wider, they speak of an India, and they use the word India Kar, the people of India, um, right in the Tamil country, uh, uh, within the first 50 years of the existence of the state of Travancore. Travancore was established somewhere around the 1750s, and this was written in 1788. Now, this kind of feelings of belonging, not exactly, of course, far from being nationalistic or anything of that sort, but a sense of belonging which is rooted with the geography of the region, and extending it to nation level concept. This may be stronger among certain groups comparatively with others. I mean, I was wondering whether this also fits in with some of the explanations that you have already given, or is it meaningful to do that? I mean, I was quite perplexed about that.
No, it's good that you bring up these kinds of examples. There are many different kinds of examples one gets from earlier periods, especially of travelers who go from one place to another. It is not unknown for people actually to even carry papers, for instance, of from the authorities of one place to identify that person as belonging to that place or being a subject of some particular ruler. Uh, but the interesting thing is that many of these kinds of identifications were not necessarily the political identifications to a state. There were people who identified, who traveled and identified with particular religious orders, for instance, or with particular business community groups, right? Business groups were very common, and they traveled from one place to another and operated along networks which were networks of similar business communities elsewhere. So there were many of these different kinds of belongings. What did not exist then was the kind of exclusive claim that modern nation states have to their citizens. The modern nation state would claim that if you are a citizen of this country, then you are exclusively a citizen of this country. India, for instance, does not even allow us to have a second passport for any other country. Some countries do, but that they do only because of specific agreements with other countries. So this exclusive belonging in the political sense, that the constitutional rights and guarantees that you enjoy as a citizen of a particular state, you do because you are legally recognized as a citizen. Otherwise, you would not have those claims. That is not something that existed in earlier periods. So, for instance, you could easily have in India people who lived in India, for instance, but paid taxes to some religious order, some religious authority. Just as they also paid taxes, local taxes to the local government. This was not uncommon at all. There were all kinds of overlapping kinds of jurisdictions over territories and peoples. That is something that the modern state, with its exclusive idea of territorial sovereignty, this is my territory, sovereign territory. No other state can have jurisdiction over the same territory. If they claim jurisdiction, then that's a disputed territory, right? That is the modern definition of national territorial sovereignty. And therefore, citizenship also tends to get framed within that idea of territorial sovereignty. Just as I said, for instance, the most progressive notion of citizenship is anyone born within the territory of the country can qualify to be a citizen. It doesn't matter what other attachments there are to that person. Now, but that still holds the sanctity of the territorial sovereignty to be supreme. So that is new. That is what the modern state has created. It did not exist in earlier times.
Okay, thank you. Thank you, sir.
Arunima, you're muted.
Sorry, Rachel, there's one last question.
Okay. It's from Papuri Boda. Since you end with Ambedkar, what would be an Ambedkarite response to the question of citizenship today?
Well, Ambedkar was writing in the 1950s. I reiterated the basic Ambedkar principle, which is that all those who agreed to live within the same constitution must be recognized as being citizens. If there are groups that do not agree to live within the same constitution, and if it is possible for them, if it is feasible, therefore, to have a separate territory where they could form their own state, they should be allowed to do so. But within every state, because there will necessarily be minorities, every constitution must guarantee protections for minorities. That is the basic principle which Ambedkar offers. So Ambedkar clearly is against the idea of ethnic citizenship by some kind of descent, by ancestry. Certainly he is against the idea of citizenship by religion. All of that is not possible. I would say that is still a good principle. It's a broad principle. Obviously, it does not solve or answer every single conceivable problem, but I think that's a good principle to operate. Unfortunately, that's not the principle that is being. That was broadly the principle of the Constitution in the 50s, but that's not the principle that's been followed. As I've been trying to explain, that the idea of citizenship has shifted considerably in the last 50 years or so.
Thank you. Professor Arunima?
Yeah. On behalf of the Kerala Council for Historical Research, I really want to thank Professor Chatterjee for taking this time and for thinking with us on the changing landscape of citizenship in India, which is so fraught at the moment. I also want to thank everybody who's participated in this program and asked questions, and for all the time that's gone into thinking together on this issue, which is so unresolved and so up in the air, and politically, I think, actually really very frightening at the moment. So thank you all so much. Thank you, Partha. Thank you so much.
Thank you very much. Thank you, everybody, for...
We may lean on you again to bring you in once again.
Okay, thank you.
Popular sovereignty next time.
Thank you. Thank you, Professor Partha Chatterjee.
Thanks a lot.
Thank you. Bye.
Bye.